You've been served with divorce papers. Your world is about to change. Fast. You need to act right away in order to keep what's yours. In this video, we'll discuss what your next moves need to be in order for you to protect your rights. You've been served. You're getting divorced. You may not have wanted it, but it's happening. You may be feeling that your spouse is coming after you, trying to take away the things you worked so hard to get. They want your money, your house, and your kids. It feels like the deck is stacked against you. You know you have a fight on your hands and need someone in your corner. But you must act now. You only have 20 days to answer the complaint you just received. If you don't do so, you will lose some very important rights. At Afford Law, we offer experienced legal help you can afford. Together, we can help you fight for everything you deserve. Don't let anyone take advantage of you or the court system. You can get through this and come out stronger on the other side. So let's talk about the papers you just received. Every divorce starts with the filing of paperwork. So your soon-to-be ex went to the courthouse, filed a number of documents, some of which have been served to you. So the first thing that has to happen is the service of process. That's when the sheriff or constable handed you the papers. Perhaps they left them at your last known address, or there are some other ways in order for you to get served. The first document we want to take a look at is the complaint for divorce. That's the document that basically sets out what it is that your spouse is looking for. They're looking for a divorce. Perhaps they want the marital home, custody of the children, alimony, whatever it is, it's spelled out in that document. You need to file an answer to that complaint. So the complaint is the first document that's filed. Then the answer is what you need to file in response to that. You've also received a summons. Now, if there are any upcoming court dates, the court dates will be on the summons to let you know when you need to be in court. You will also have received a tracking notice. This is a document generated by the court. It assigns your case to a particular judge, and it puts your case on one of two tracks, either the uncontested track or the contested track. If you're being served with papers, your divorce is on the contested track. Next is the notice of automatic restraining orders. So every time a divorce is filed, these automatic restraining orders go into place. Now, it's not a restraining order as in the cases of domestic violence or something along those lines. It's not telling you to stay away from somebody or not to have any contact. What it's intended to do is to prevent the parties from basically getting rid of assets that may be divisible by the family court judge. So in that order, you're told that you can't sell any of your assets, you can't hide any of your assets, and things along those lines. You do obviously need money to live your life, so you are able to use the funds that you have for your reasonable living expenses. You can also use the funds that you have on hand for reasonable attorney's fees associated with the divorce itself. Now, it's very important that you file an answer to that complaint as quickly as possible. You only have 20 days to file your answer. If you don't file within the 20 days, the other party, your soon-to-be ex-spouse, can ask for a default judgment. Basically, a default judgment is saying to the court, "Judge, please give me everything I've asked for in my complaint because the other party hasn't responded." If you don't respond within that 20 days and a default judgment enters, basically, you've lost the case. You've given up all the rights that you have without even getting into court. So you must act now or lose your rights. So if you get your answer in within the amount of time, the next step is probably going to be the mandatory self-disclosure step. You have 45 days from the time that you were served to file additional documents. So does the other party. So you have 45 days to file a number of very complex documents. One of them is the financial statement. You have to fill out a financial statement explaining to the court exactly what your income is, what your expenses are, and it goes into great detail. You must also file tax returns for the past 3 years. You must supply them to the court and to the other side. You must supply 3 years of bank statements. Also, any copies of any loan applications or any mortgages that you have filed in the past 3 years. You also have to file a statement for investments or retirement accounts in the last 3 years as well. You must provide your 4 most recent pay stubs and information on any available health insurance. There's a lot that goes into it, so that's just the next step in a very long and complex process. Now, another step in the process is dealing with temporary orders. Temporary orders are just what they sound. They are orders from the court which are temporary in nature. They're temporary during the course of the divorce itself. So your divorce is on the contested track. The court likes to have contested divorces finished up within 14 months. Sometimes cases go longer, sometimes they can be finished up within that period of time. However, 14 months is a long time, and that's why temporary orders are necessary, because you have to have something in place during the course of that time. Temporary orders will address many issues that you have in the divorce. So things such as who lives in the marital home during the divorce, who pays the bills for the home, will there be any spousal support or alimony that needs to be paid within that period of time. If you have children, child custody, child support, and reasonable parenting time will all be addressed at the temporary order hearing. Temporary orders are not only important because that's what's going to be in place while your divorce is proceeding through the process, it's also very important because when it comes time for a final order, temporary orders are oftentimes relied upon by the judge when setting that final order. Let's say, for instance, you are awarded custody in the temporary order. When it comes time for a final order at the end of the divorce, you will already have shown the court that you are a capable parent, that you can take care of the children, and the children should not be upset in their normal routines because you've been doing so for the past year or however long the divorce is taken. So you'll be in a much better position to ask for permanent custody of your children if you have temporary custody of them beforehand. You have important rights when it comes to your divorce. You'll lose those rights, however, if you don't answer in a timely fashion. The clock has started ticking from the moment the sheriff handed you those papers. You only have 20 days to file your answer, and the answer must be complete, it must be accurate, and it must contain the information to put you in the best possible position. You must act now. Call us today for a free virtual consultation. We'll get you started on the road to protecting your rights. For more information on Massachusetts divorces, please feel free to visit our next video.